Welcome to Open Minds, a Freedom of Thought podcast series, interviewing the people who bring courage and independent thought to the challenges of today.
Welcome to today's Federalist Society virtual event. This afternoon, Tuesday, June 20th, we will be discussing the ethics of client coercion. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. Today's discussion addresses an important question for the Freedom of Thought Project. What influence, if any, should a law firm's clients have over a firm's representation of other clients? Specifically, is it ethical for an in-house attorney to leverage his employer's economic clout to interfere with their outside counsel's client decisions on unrelated matters? And is it ethical for attorneys to give in to such pressure? As always, please note that all expressions of opinion are offered today as the opinions of the experts on today's panel. We encourage our audience to submit questions for our panelists through the Q&A feature at the bottom of your screen. After our speakers have offered their opening remarks, our moderator will turn to submitted questions to direct the panel discussion. And joining us as moderator, we are grateful to have David Latt with us to guide our conversation. David is a lawyer turned writer who publishes Original Jurisdiction, a newsletter on Substack about law and legal affairs, where he has been chronicling what seems to be an evolving thinking on the representation of controversial clients and causes as a professional norm. So how should we think about efforts to deter lawyers from representing controversial clients? Is it consistent with the norms of the legal profession? Do efforts to influence the legal process via access to counsel threaten the rule of law principles? And are existing rules sufficient to protect professional independence and ensure access to counsel? Thank you all for being with us today. David, the floor is yours.
Thank you so much for the kind introduction, Alita, and it is really wonderful to be here to discuss a very important and interesting topic. So before we get to the panelists, I'm just going to provide a little bit of background on the issues we'll be discussing today. Using various forms of pressure to try and get law firms and lawyers to drop controversial clients or causes is nothing new, and it has been used across the ideological spectrum. Over the years, we've seen criticism of lawyers and firms that have represented everyone from Guantanamo Bay detainees to former President Donald Trump. But my sense, as someone who has been observing and writing about the legal profession for almost 20 years, is that it's increasing, which is why it's a good topic to discuss today. Perhaps the most prominent recent episode came a year ago this month, when Paul Clement and Erin Murphy, two very prominent and successful appellate and Supreme Court litigators, were basically forced out of Kirkland and Ellis over their representation of clients advancing Second Amendment claims. According to the Wall Street Journal, several major clients of Kirkland began expressing reservations to the firm about Kirkland's work on behalf of Second Amendment rights, especially in the wake of several mass shootings. So after Clement and Murphy prevailed in the Supreme Court case of Bruin v. New York State Rifle and Pistol, they were given a choice by Kirkland: drop their Second Amendment cases, including ongoing representations, or leave the firm. They chose to leave Kirkland, and they now have their own boutique, Clement and Murphy. In a statement, Paul Clement explained that, and I'm quoting, "Anyone who knows us and our views regarding professional responsibility and client loyalty knows there was only one course open to us. We could not abandon ongoing representations just because a client's position is unpopular in some circles." As Clement and Murphy noted in a Wall Street Journal op-ed about their leaving Kirkland, this isn't the first time they have had to leave a law firm and to stick by a client. Back in 2011, they left King & Spalding after that firm told them they could not represent the House of Representatives in defending the Defense of Marriage Act, or DOMA. But there's an interesting difference in public reaction to these episodes. In 2011, King & Spalding was roundly criticized from across the ideological spectrum for forcing out Paul Clement. The New York Times even wrote a staff editorial decrying King & Spalding's action as, quote unquote, deplorable. This time around with Kirkland, there was relatively little reaction, and it had a partisan skew to it. Conservatives seem to be far more troubled than people on the left. It's also interesting to compare the muted response to Kirkland's action with another incident around the same time, not involving a client choice, but definitely involving a client telling a law firm what to do. In May of 2022, so a month before Clement and Murphy left Kirkland, it came to light that Elon Musk tried to force Cooley, a law firm that handled a lot of work for him, to fire an associate who had previously worked at the Securities and Exchange Commission on an investigation of Musk. It wasn't an actual client conflict issue. The associate wasn't working on any Musk matters. It was just Musk being Musk. Cooley stood by the associate and stood up to Musk and said they would not fire that associate. And they won plaudits for doing so. They were generally praised for what they did. But let me offer the other side of the argument here. And this is, by the way, an issue that Federalist Society folks can and do disagree on. I've been on the so-called FedSoc speaking circuit, giving a talk entitled Free Speech, Wokeness, and Cancel Culture in the Legal Profession. And most of the time, for most of the talk, I feel I'm preaching to the choir, for example, when I'm criticizing shout-downs of conservative speakers. But when I discuss the Kirkland and Paul Clement situation, I actually get a lot of pushback from largely conservative or libertarian audiences. Here are 3 points that get raised with me. First, isn't this just a business decision? Law firms are businesses, and they are making a rational business decision to prefer one client over another. They do this all the time. What's the problem? Second, is it dropping a firm just a type of boycott, of which there is a fine tradition in this country? Boycotts were used to great effect during the civil rights movement. More recently, people boycotted Bud Light because they were opposed to its hiring of a transgender influencer. What's so wrong with consumers? In this case, consumers of legal services using their economic clout to advance their views. And then third and finally, law firms have rights under the First Amendment too. If a law firm wants to brand itself the woke firm or the MAGA firm, what's wrong with that? Why should a progressive firm like Kaplan Hecker have to have conservative clients, or a conservative firm like Consovoy McCarthy have to have liberal clients? So we're fortunate today to be joined by 4 great guests. I will introduce them briefly in the order in which they'll speak, but you can find their bios online. First up is David Boies. He's one of the nation's leading trial lawyers, but perhaps more relevant for present purposes, he is the chairman and founding partner of a major law firm, Boies, Schiller, Flexner. He will explore the history that got us to this point, including changes in both the legal profession and society more generally. Second, we will hear from Professor Michael McGinnis, who teaches legal ethics and professional responsibility at the University of North Dakota School of Law, where he served as dean from 2019 to 2022. He described himself to me as a recovering dean. Professor McGinnis will situate these issues in the context of the rules of the legal profession and the history of the profession. Third, we will hear from Professor Carissa Hessick of UNC Law, where she is the Ransdell Distinguished Professor of Law. She is a leading scholar of criminal law, and she teaches professional responsibility as well. She'll give us some perspective on how law students today feel about these issues. Finally, we will hear from John Moran, who is a partner in the DC office of McGuire Woods, where he is a member of the Government Investigations and White Collar Practice. Before McGuire Woods, he worked in the Solicitor General's office. He will discuss what can be done to address the problems described by the other panelists, and he will even outline a specific proposal. We will then have a moderated discussion in which the panelists can chat with each other and also take your questions, which you can put into the Q&A. Now, without further ado, I'd like to turn the floor over to David Boies. David.
Thank you. It's a pleasure to be here. This is not a new issue, as you say, and indeed, I founded Boies, Schiller, and Flexner in 1997 because of, in some senses, this very issue. At that time, Time Warner, I was a partner for Cravath, Swaine & Moore, and Time Warner, who was the largest client of Cravath at that time, objected to my representing the New York Yankees against Major League Baseball. And in order to avoid a very difficult business situation, I left Cravath and founded the firm. So the attempt by clients to influence lawyer behavior is not new. I do think, however, it has become much more significant in recent years. And I think part of that is changes in our society. I think part of that is traceable to the divisiveness in our society and the extent to which people on one side tend to believe that the people on the other side are not only misguided but somehow fundamentally wrong, even evil. And that they believe that if somebody is representing a client with respect to interests opposed to them that they believe strongly in, that there is some type of bad behavior going on there that needs to be punished and tried to be deterred. I think another aspect of it, though, is the changes in the legal profession. And it was interesting to me, as you said, people give pushback. Well, lawyers are just business people. They're making business decisions. They're preferring one client over another. And I think that that is the way a lot of lawyers have come to view their occupation, which is that it is just simply another business, as opposed to being an important component of our justice system. And I think we lose something when we view the legal profession as simply another business, where we are going to market our products the same way everybody else markets their products. We're going to choose our clients the same way, that we have no particular ethical obligations any more than a purveyor of soap or bathroom tissue. So I think that those two trends, I think, have come together to make this a more significant problem than it has been historically. And I think that we lose something as a society, not merely as a profession, but as a society, when lawyers view themselves not as professionals with an obligation to the justice system, but as simply business people whose only goal is improving the bottom line. I also think that the breakdown of long-term client relations has also contributed to it. Historically, client-lawyer relationships tended to be pretty durable. You knew that when you gave your client the best advice, even if the client didn't like that advice, you were unlikely to endanger your relationship. Today, it's much more a profession where you're making pitches for business. Clients are moving from lawyer to lawyer without much durability there. I think that puts more pressure on the lawyers to try to please the clients. I think that lawyers often feel that they need to sell clients on themselves, and the way you sell the clients on yourself is by identifying with what their interests are. So I think all of these things have contributed to where we are, and I think all of them have contributed to a situation which, in the long run, is damaging to the profession and damaging really to our justice system. The ability of people to get representation, even when they're unpopular, the ability of lawyers to represent people who they choose to represent without feeling that they're going to get boycotted by clients or law students or the lawyers, I think has always been essential to what we've thought of as our professional ethical responsibilities.
You're muted, David.
Sorry, actually, I didn't really need to say anything other than to turn the floor over to you. So go ahead, Professor McGinnis.
Thank you, David, and greetings, everyone. It's my pleasure to be a part of this very important discussion. My role is going to be to set out some background to go see how we got here, and where we were, and what some of these principles of legal ethics and the history of the profession and the norms of the profession that are at stake in these conversations. So when talking about lawyers' professional independence, that'll be sort of the overarching theme of my comments. Historically, they've operated at these norms have operated at three basic levels. The first is the institutional independence of the legal profession itself, which is recognized in the law as a tradition of being a self-regulating profession. The second is what I'll describe as structural or organizational independence. And this is possessed in different ways and degrees by firms, whether they're private law firms, government agencies, or other sub-institutions within the profession, such as law school. And then third, individual independence of lawyers in their various roles within the profession. So these traditions, principles, and prerogatives of lawyers in professional independence are implicated in some way at each of these levels by the phenomenon of client coercion, which is the topic of our discussion today. But I'm going to focus primarily on the historical traditions and norms relating to the second and the third, the organizational independence of firms and the individual independence of lawyers in fulfilling their roles, which are predicated primarily on the societal value of upholding the rule of law and promoting access to justice through the adversarial process. And as David Latt alluded to in his opening, there is some tension between 2 and 3, individual prerogatives of lawyers to represent clients and independence of firms to establish an identity as far as what their role in the profession is going to be. So starting with individual professional, I'm going to work through the rules. I'm a professor of legal ethics, and so some rules of professional conduct for background I think will be very helpful. Rule 1.2b of the rules of professional conduct establishes what's been described in legal ethics as a principle of moral non-accountability. And it says that a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. So it's designed to create some space so that you're not identified as agreeing with the client simply because you're providing them with legal services in a particular matter. There's also Rule 2.1, which also deals with the concept of independence very explicitly. And this is the rule of professional conduct on the role of an advisor of a lawyer. And it says that in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. There's a principle behind this rule. It's not, in fact, that's what stands out from it between it and the conflict of interest rule of 1.7. What it does is it establishes a sort of resistance principle that lawyers are not supposed to be necessarily captured by clients, but sometimes deliver the advice that the client needs to hear or should hear, even if the client doesn't necessarily want to hear that. And there's also a societal benefit to that too. Some is to tell them this is something that is going to have harms to third parties or has implications beyond simply you achieving your immediate short-term goals. And I think this prerogative, though, also it's always usually thought of as client capture, but also I think as a indirect effect, it could be extended to the idea of other clients, so that other clients aren't supposed to be impeding your ability to independently advise certain clients. So resisting the sort of pressure to cabin your advice to one client because of concerns about what other clients will think is a part of that as well. Next is going to be Rule 1.16b, which is the general provision 1.16 on accepting, declining, or terminating representation. 116b is the category of permissive withdrawal. And these various avenues, and I won't go into the details of them, you can check it out yourself, but they provide various avenues for lawyers to disengage from the representation of a client under certain circumstances. And it's a way, among other things, of promoting their independence and avoiding capture. But note that it's individually directed. It's not designed as a means for other lawyers in the lawyer's firm or other clients to pressure a lawyer to withdraw based on their concerns about, for example, 116b4 says the client insists upon taking an action that the lawyer considers repugnant or with which the lawyer has a substantial disagreement. That's supposed to be about the lawyer's individual response, not what other clients of the firm consider repugnant or disagree with. So now move quickly to 5.4, which is actually a rule that's titled Professional Independence of a Lawyer. So it's right out there in black and white. It's essentially a conflict of interest rule with several parts. With dealing with individual independence of lawyers, it provides a lawyer, and Part C, a lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services, end quote. The comment to the rule says that it expresses traditional limitations on permitting this third-party regulation and alludes to Rule 1.8f, which is the provision on accepting compensation from third parties to represent a client only with the informed consent of the client. So that the idea is to protect against influence by the person who's financially supporting the regulation. So even though on its face, that's what it's doing, it's about directing or regulating by a fee-paying third party involved in the same client matter for which the fees are paid, I think as a matter of legal ethics principles, there's a corollary, which I think we could extend here to our situation that we're discussing today, that lawyers should remain professionally independent in their exercise of professional judgment involving who to represent and what advice and advocacy support should be given to other clients, even though a client who provides financial support to the lawyer's practice, perhaps very substantial, through the payment of legal fees and other matters, might disagree with the representation of that client or the work being done on that client's behalf. So the rule itself doesn't get there, but there's a corollary principle I think that we can discuss here today. And then next, 5.6, which the provision has two parts. A lawyer shall not participate in offering or making a partnership, shareholders, operating employment, or similar type of agreement that restricts the right of a lawyer to practice after termination of the relationship, except for retirement benefits. This is against non-competes. And part B, an agreement in which the restriction on the lawyer's right to practice is part of a settlement of a client controversy, end quote. The purpose of these provisions is to provide access to lawyers for the public. As part A, to curtail a firm's promotion of business self-interest at the expense of this important principle of access, to essentially take someone off the playing field for representing other clients through a non-compete. And in part B, to prevent an individual lawyer from allowing the favoring of the interests of one client in a settlement to be to the detriment of future clients by limiting his or her professional independence on client selection. One of the themes here is that independence exists for a greater purpose than the self-interest of a lawyer or a law firm or for a single client. Talk a little bit about organizational independence for a moment, just more in brief. Another part of Rule 5.4 are A and B that deal with prohibition on sharing legal fees with non-lawyers, and B deals with not forming a partnership with a non-lawyer if the activities consist of the practice of law. This is the area of controversy from decades about organizations or multidisciplinary practice endeavors to try to have co-ownership arrangements with non-lawyer persons or entities. This part of the rule is frequently defended against criticism and efforts to liberalize it as being necessary to protect core values of the legal profession against third-party interference. But in that case, it's that kind of non-lawyers through ownership. I think there's a principle that could be involved here about allowing financial considerations to impact your representation of current clients because of the fact that you're dependent on or wanting to please maybe a significant fees paying client. Just want to touch on for a moment an argument that has been frequently asserted, I've heard asserted by corporate clients and internally adopted with big law firms about why it's not only appropriate but ethically justified to either prohibit any lawyer in the firm from taking on or making them drop based on ideological or controversy objections as a particular other client, because it creates a positional conflict, which under 1.7 would be a material limitation conflict, and say, well, that material limitation is imputed to the entire firm under 110. Therefore, the firm should not be representing this particular client whose position we find objectionable. This argument isn't supported by the text of the rule. Let's be point blank about it, especially in the context of law firms that consist of many dozens, hundreds, or even thousands of lawyers. It really exists in dealing with, or there's a provision in the rule of positional conflicts, comment 24, that says a conflict of interest exists, however, if there's a significant risk that a lawyer's action on behalf of one client will materially limit the lawyer's effectiveness in representing the client in a different case. For example, when a decision favoring one client will create a precedent likely to seriously weaken the position taken on behalf of the other. So there's a relatedness requirement that's involved here, and just simply say we object to this particular controversial client or this position, for example, the Paul Clement situation involving gun rights, that isn't materially connected in a substantive way to the subject matter of the other representation. It's simply a red herring argument, just for general information for our audience in case you hear that one brought up. Okay. I'm going to conclude this with stepping back a little bit on this idea of independence generally in a story. I promised some history, and so here's some history. You may have heard the story from back in the 18th century, the time of the founding. John Adams, who was a lawyer, his defense of the British soldiers after the Boston Massacre. For those of you who haven't heard it, in 1770, British soldiers were pelted with stones and other objects fired into a crowd and killed 5 people. Adams agreed to defend the soldiers when others would not do so. As David McCullough's biography of John Adams describes, he was, quote, firm in the belief that no man in a free country should be denied his right to counsel and a fair trial. As a lawyer, his duty was clear, he believed, despite the hazards to his hard-earned reputation. Arguing self-defense, he won an acquittal of 6 of the 8 soldiers and spared the lives of the other 2, who had fired directly on the crowd, were convicted only of manslaughter. The assumption behind the principles of professional independence is that lawyers have the courage to defy self-interest and outside pressures, including friends, members of the community, professional colleagues inside and outside their firms, and as we've discussed today, other clients, and will not be deterred from fulfilling their professional duties to their clients, the public, and the profession as a whole. In closing, in my opening remarks here, without a robust exercise of professional independence in the face of pressure from other clients to deprive individuals, entities, or certain disfavored causes of the benefit of strong legal representation and access to the justice system, the premises behind the historical prerogatives for the legal profession's predominant regime of self-regulation, which is already weakening and diminishing through a variety of legislative regulations and controls that have already been put into place and may continue to grow, this will only further erode. In essence, a future Congress may step in to address the situation unless lawyers and law firms do what they should to push back against these forms of client coercion. So thank you, and I look forward to the rest of the conversation.
Okay, thank you so much, Mike. Now I'd like to turn it over to Carissa.
Great, thank you, David. I'm really happy that I was included today because I come at this topic not as an expert in legal ethics like Michael or someone with a long and storied practice career like David. Instead, I come at this topic just really as an observer of public attitudes, and mostly the attitudes as they're expressed in sort of the microcosm that is the required professional responsibility class that I've been teaching now for many years. As both David Latt and David Boyce have mentioned, there is an unfortunately long tradition of pressure brought to bear on lawyers not to take certain clients. As someone who studies the criminal system, I've seen this most often expressed when people talk about the choices of those who decide to become defense lawyers, especially defense lawyers in the indigent defense system. The question that's asked to them is, how could you spend your career representing people who did those terrible things? Aren't most of them guilty anyways? More recently, I think we've seen some high-profile examples of specific lawyers facing a lot of pushback for their clients that they've taken on. You know, Jamie Gorelick, who was Deputy Attorney General in the Clinton administration, faced a lot of blowback when she took on Jared Kushner as a client. Ronald Sullivan, who is both a practicing lawyer and a professor at Harvard Law School, when he joined Harvey Weinstein's legal team, there were student protests, and the university ended up removing him from his position as faculty dean at one of the residential colleges. So, of course, as a self-regulated profession, it's up to us as lawyers to decide what professional responsibility rules should govern us. And I don't think that we should allow public pressure to dictate the substance of those rules. But I think we also need to be quite aware of the fact that that sort of pressure doesn't seem to be going away. If anything, it might be getting worse, especially if we think about unpopular defendants or politically charged cases. Some lawyers are never going to want to risk their reputations on the sort of public blowback that we see in some of these cases. And so if we really care about access to justice, we need to care about this social and cultural pressure in addition to the formal structure of the professional responsibility rules. And when I think about that social and cultural pressure, I'm quickly reminded of the fact that there are some lawyers who thrive on wading into these controversial cases. Especially with politically charged cases, there are firms that actively seek out clients, usually on one side of the political issue. They then build a professional reputation and a business as a progressive lawyer or a conservative lawyer. In fact, I think Jamie Gorelick only faced the blowback that she did because as a Democrat, she took on a Republican client who at the time, you know, his father-in-law was in the White House and for at least half the country wasn't a very popular president. And I know that it's easy for us to assume, given the principles of professional independence that Professor McGinnis was talking about, that this is appropriate, but I'm not so sure that that's what we should want as lawyers, to have cases only handled by the lawyers who seek to further a particular political cause or the fortunes of people in a particular party. And I think the professional rules here don't have much to say about those choices. If anything, they protect the independence of lawyers to make precisely those choices. In fact, they say, as Michael was telling us, that lawyers get to make the decisions about who their clients are and which clients they should take, right? So we have that commentary to Rule 1.2 that says a lawyer's representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views or activities. And so they seem to say we shouldn't judge lawyers based on who they decide to represent or the causes that they choose to champion, that we shouldn't assume that they support those causes, or want those people to win. But that's not the only rule that talks about this issue, right? Rule 1.16, the rule about terminating representation, says a lawyer may withdraw, as Michael was telling us, a lawyer may withdraw from representing a client if the client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. So, to be clear, a lawyer can withdraw at any time if it's not going to materially adversely affect the client. This is a rule that allows the client to the lawyer to terminate representation, even if it would hurt the client, if they fundamentally disagree with what that client is doing. So my students, when I point out these rules, they like to call these the have your cake and eat it too rules of representation. That you, as a member of the public or another person, can't assume that a lawyer approves of his or her clients, but at the same time, the lawyer can leave their client in the lurch if they don't like something that the client is doing. Now, I agree with Michael that within the profession, we justify these rules under a broader heading of professional independence. And I think professional independence is an important and laudable value for the profession to have. But my students who've not yet become members of the profession, they see it largely as hypocrisy. They see it largely as self-serving, and they don't, I think, see that value in professional independence. And anecdotally, I'll say, it seems to me that in recent years, my students are quicker to come down on the side of course, lawyers should be able to get rid of their clients if they don't like what they're doing, and quicker to come down on the side of, and we should judge them when they fail to do so. So now I have a few theories, because one of the wonderful things about being a professor is I get to ask my students as many questions as I want, and they have to answer me. And also teaching the required professional responsibility class, anytime a student expresses a strong opinion about anything, we're going to spend a lot of time on that issue rather than like fee sharing or escrow accounts, which don't seem to engender strong opinions. But this topic does. And so over the years, I've gotten a lot of feedback from the students that justify this view, that we should judge lawyers for their clients sort of view. Now, for some of these students, I think it's actually relatively straightforward. They have come to law school because they want to change the world. And for them, clients and the cases that you take are reflections of the world that you want to see. It's very straightforward. I think for some of them who maybe don't come to law school to change the world, they realize pretty quickly that lawyers, most lawyers, get to pick and choose among their clients. And they don't understand why you wouldn't, sort of use who your client is and what the representation would accomplish if you're successful as at least one decision-making point to consider. I also think that there are some other ideas from the students, things that might not have occurred to me as sort of like a boring law professor. Some of them see this, as they see a lot of issues, as just a question of power. And they think that the world exists as it is based on who has power and who doesn't have power. And if there is social capital or a cultural movement behind helping certain groups or hurting other groups, and those are the groups that they favor or disfavor, they think the use of power is how the world works, and this sort of client coercion or public pressure is one way to exert power. I think some of them, they think that turnabout is fair play, right? That a number of the groups that have power now, social power, economic power, didn't in the past. And they are aware of the long tradition of groups in power pressuring lawyers not to take certain clients. And so they think it's only fair for the other groups to have their day in the sun. I also think some of them just aren't convinced that people's views on access to justice and people's views about lawyer independence are entirely divorced from the issues under discussion. Were people upset about Paul Clements and the various law firms he's been asked to leave if they didn't share the substantive views underlying the cases he was taking? Would this issue be as big of a deal right now with groups like the Federalist Society if there weren't conservative clients and conservative issues who are on the losing side? I don't know that I necessarily share that view. I think that there are plenty of people who can subscribe to neutral principles, but my students don't necessarily see it that way. And I'll say, I think that they also pay a lot of attention to the very high profile cases and examples of lawyerings that are out there. And it tends to confirm their views that you use your position as a lawyer to bring about the change that you want to see, right? So many of the cases that we see out there right now are lawyers who are on one side of an issue, and that's the issue that they're litigating. Right? So just to take abortion, for example, you have people who are committed feminists who are out there fighting for reproductive rights. You have people who have deeply held religious views who are fighting on the side of a pro-life agenda. This is so sort of ubiquitous within the profession that there's a vocabulary to talk about it, right? We talk about impact litigation, cause lawyering, movement lawyering. And as someone who teaches professional responsibility, I try to push back on this idea that law is just another place where you can fight political values, right? That law is just politics by a different name. And I find myself highlighting precisely the rules that Professor McGinnis was talking about, right? The role of counseling clients, respecting the rights of third parties, that this isn't about winning at all costs. That the rules actually talk about diligent representation rather than zealous representation. And the word zeal got relegated to the commentary alongside all sorts of other sort of sentences that are warning people not to try to win at all costs and that they have to be polite and can't be awful. I do have to say, though, on a sort of pessimistic note, it's not really clear that I've made much progress in the classroom about these things. And at times it feels a bit like I'm shouting into the wind, because whatever does happen in my class, even if I can convince my students, the reality is there are some lawyers who spend their entire careers simply fighting for one political side. The profession is in many ways very divided. I am always happy when groups like FedSoc take the opportunity to try to facilitate debate and discussion across the two sides. But groups like FedSoc and ACS, unfortunately, sometimes become identity badges in that political war, just identifying what side of the divide that you're on, which is also problematic. Now, I don't, by the way, as I say to my students, I don't have any solutions to offer. I don't think that informal boycotts by clients of firms that take on clients or causes that they don't like are good. I think they probably make this situation that I'm talking about worse. But I do think we need to note that client coercion is just one symptom of this larger illness. Now, of course, focusing on the relationship, especially the relationship between in-house counsel and outside counsel, gives us the benefit of the tools of professional responsibility and the rules of professional responsibility to push back. But I don't know that simply pushing back within the rules is going to necessarily address the sort of broader cultural phenomenon that'll probably still persist in curtailing access to justice. but hopefully I'm wrong about that.
Okay, thank you so much, Carissa. So you said you don't have solutions, but maybe John does. So John, the floor is yours.
We'll see. So good afternoon. Thank you to Alita and to the Federal Society for hosting this, to our moderator, David Latt, to my fellow panelists, and to everybody who's here attending. Since returning to private practice from the Justice Department in 2021, I've had the chance to engage in a number of great conversations about the state of modern law practice and the issues we face. And this is just one of those threads, but it's a really interesting and important one. I come at this as an attorney who represents politically unpopular clients, at least unpopular in certain circles. I do, and I intend to in the future. But of course, political popularity usually depends on where you sit. I'm a partner, as David mentioned, in the DC office of McGuire Woods and part of our government investigations and white collar practice. I also help to lead our congressional and political investigations practice, which more often than not involves representing a client that has drawn the political ire of one party or another. And from that vantage point, I think it's vitally important that attorneys in private practice have the freedom to represent clients that other clients might disapprove of. As Mike outlined, I think that position reflects the best values of our profession from the founding era through the civil rights movement to today. But I also think it's essential to effective client service. I might be naive, but if I were an individual or a company facing a high stakes investigation, I don't think I'd want to be represented by a lawyer who was going to jump ship when the going got tough. I would want somebody that had the courage to stick with me even when things got unpopular. And I would also pause here to note, this just occurred to me as we were going through this. It's the concern here is not just about dropping a client. There's obviously a lot of harm in dropping a client, but it's almost worse in many ways if this type of pressure is causing lawyers to continue representing a client, but affecting the types of arguments that they're willing to advance on behalf of that client. And that's something that can often happen without the client's informed consent, or even frankly, without the lawyer sort of consciously making a decision to do it, but just thinking, sure, I'll continue to represent this client, but I'm not going to make X, Y, or Z argument, or I'm not going to file X, Y, or Z case because I'm worried about how other clients might react. So today we've heard sort of a diagnosis of the challenge that lawyers in modern practice face. We have a sense for the tension between kind of the current state of affairs and the traditions of the profession and the ethical principles that have traditionally governed our practice. And we have a somewhat sobering account from Professor Hessek about how the newest generation of lawyers comes at these issues. So in the time I have left, I wanted to share some practical thoughts on what can be done. I'm confident that there's no silver bullet here, but at the same time, I don't think the matter is hopeless. As this event itself reflects, there are people in the profession who care about these issues and are willing to engage on them. The first thing we need practically is individual moral courage. The herd mentality has a strong pull, and it only gets stronger when staying in the herd is tied to your income, your benefits, and your professional standing. And even for those of us who make a living representing beleaguered clients, unpopularity can come in a lot of different flavors. And if you want to, you can have a great career without ever representing a client that's going to give your other clients a substantial amount of heartburn. And so, there's a lot of pressure simply to do that. But it doesn't have to be that way. There are cases where lawyers can stand up for their clients. And as we've already talked about today, there are a lot of good arguments that a lawyer can make when they're doing it as to why that's the right thing to do. And so we need people to do that. But still, there are going to be many lawyers, even really very good lawyers and well-intentioned lawyers, who are going to avoid or drop representations of unpopular clients to avoid rocking the boat. And they're going to have any number of ways to rationalize that decision. And frankly, until you've stood in their shoes, I think it's hard to criticize them for doing that. So individual effort on its own is not going to be sufficient. The second is a collective effort to establish a new norm, or if you prefer, to reestablish an old norm. This event is a great step and a great example, and knowing Alita, this won't be the last such effort. There is strength in numbers, and it's easier to take a stand yourself when you see that other people are doing the same thing and when you know that there are people rooting for you. And then the third would be to formalize that norm in the ethics rules that govern our profession, which of course won't happen without building consensus around it. Now, one way you could do that would be through a new rule, and there's an example that I'm going to give here in a moment and talk about. It could also come through the interpretation of the existing rules. So for example, if the ABA put out an opinion that says 1.2b says that a lawyer's representation does not constitute an endorsement of the client's political, economic, social, or moral views or activities, and they say that means that if you're a client and you call up a lawyer and say, I don't like the political, economic, social, or moral values or views or activities of your clients, that they're violating the rule, and that's conduct that can be disciplined under the rules. That would be it might be an effective tool as well. But I think the model rules as a whole at the national level, and then obviously the state bar rules that implement that in individual jurisdictions, those provides the standards and norms that guide our profession. And even if you're not in the context of a disciplinary enforcement proceeding, they have a meaningful influence in how the profession views itself and how individual lawyers conduct themselves. I'm not so naive to think that everybody spends all their time reading the rules and aligns themselves, wakes up every day and refreshes themselves, and that's how they guide their practice, but it does have a role to play. There's also a practical element that when, somebody who does take an individual moral stand to continue representing a client, notwithstanding the strong objections of other clients, it's tremendously helpful to them if they have something to point to and say, I'm just upholding this particular rule of conduct that governs our profession, and here it is in black and white. I can point you to it. So what might such a rule look like? I'm going to share my screen here in a second. All right. So this is one approach that's come up in some of the conversations I mentioned with other lawyers who care about these issues, and it would be an amendment to Model Rule 5.6 that would add a new subparagraph C. As Mike outlined, Model Rule 5.6 describes prohibited agreements that would restrict a lawyer's ability to represent clients, and it makes clear that an attorney is prohibited from entering into or even offering to enter into one such agreement. The first, under paragraph A, is essentially a non-compete that would restrict a lawyer's ability to represent clients after leaving his or her firm. And the second, under paragraph B, is a settlement agreement that restricts the lawyer's ability to practice. So suppose we added a third, an agreement between a lawyer and a client which restricts the right of the lawyer to represent another client. So then if a client came to me and said, hey, if you want me to keep sending you work, I need you to agree not to represent that other guy anymore, I could respond, sorry, I can't agree to that. It's not just my view, it's a prohibited agreement under Rule 5.6C. Present this as food for thought. I look forward to questions and discussions with those attending, but there are just a few things I wanted to point out about this, this potential for a rule. First, the language here is not limited to certain reasons why a client might try to restrict another's representation. For example, it doesn't say an agreement which restricts the lawyer's right to represent another client based on an ideological disagreement with that other client. I think, for one, it would be hard to capture precisely the types of reasons that should be prohibited without creating wiggle room that could swallow the rule. But secondly, it's not necessarily bad to sweep in wholly non-ideological reasons, and that feature may actually increase the likelihood of building consensus around this type of norm. Professor McGinnis talked a little bit about positional conflicts, and I can tell you from the inside of private law practice, that's a term that gets thrown around a lot with a wide range of meanings that go well beyond what the rules actually say. And I think anything like this that would sort of tighten discipline around what is really a positional conflict, might be a salutary have a salutary effect on the practice of law, but B, it might be a way to get people who aren't necessarily concerned about the issues we're talking about today to nevertheless buy into the rule and say, yeah, I'm I find myself limited in my practice by my client objecting to me representing, people in a competing industry or even their own competitors, even when there's not a real legal conflict under the rules. At the same time, it needs to be clear that this rule would not alter the ordinary conflicts rules or prohibit a client from enforcing them. And so, what's here on the screen, that's addressed through a comment. It could also be incorporated into the text of a rule. This version says paragraph C does not apply to the rules on conflicts of interest, nor to an agreement between a lawyer and a client that requires the lawyer to abide by those rules. Third, this language would not restrict, as we've discussed a little bit, this language would not restrict a law firm on its own initiative from deciding what types of cases and clients it wants to represent. It focuses on the lawyer-client relationship rather than the law-partner relationship. And that's intentional. The point is not that lawyers and law firms shouldn't be able to pursue a particular cause or brand. I think that the issue that we're discussing today and that a number of folks have put a finger on is uniquely about the type of pressure that comes from the client-lawyer relationship as it relates to other clients in unrelated matters. And lastly, there's always going to be some difficult line drawing. So for example, the distinction between a client making an independent choice about which law firms it wishes to use and perhaps informing those law firms that, we don't do business with firms that take on these types of cases on the one hand, and then a prohibited agreement here on the other hand. But, that's a line that we walk in the law every day. Antitrust is a particular area where there's, independent action that's lawful, there's concerted, coordinated action that's unlawful, and there are often some difficult distinctions that have to be made between the two, but that doesn't mean that we throw out the rule altogether. And I also think in this context in particular, the enforcement mechanisms of the ethics rules provide ample flexibility to implement a rule without unfairly punishing lawyers who act in uncertain territory and might later be deemed to have, crossed the line or not. So with that, thank you again, and I'll turn things back to David. I expect we'll have some questions.
Yes, thank you so much, John. Really appreciate it. So let me actually stay with you for a sec and ask, your proposed rule focuses on agreements. What about softer forms of pressure? What about clients just kind of calling up the relationship partner saying, hey, we saw this in the news, we don't like this? Is it possible to draft a rule that addresses this, or is it just too elusive?
So, a couple thoughts on that. Again, kind of this is based largely on a lot of discussions that I've had recently with other people in private practice. One, I think it is hard to craft a rule that gets at sort of softer forms of coercion. Eventually informal conversations do bleed into an agreement, right? And that's kind of goes back to this issue of line drawing. That's something we see, all the time where somebody says, no, I wasn't part of the conspiracy because all I did was have some, general conversations about this or that. And at some point that crosses the line into agreement. I also think there's if we're talking about something that would be in the rules, there'd be some prophylactic, there's a little bit of a chilling effect that's maybe not the worst thing in the world. If somebody says, hey, I'm not offering an agreement, but I'm kind of flirting around the edges, then they might think twice and say, you know what, I'm not gonna pick up the phone and do that. And then third, again, I think if we're talking about truly independent action, to me, and I think others disagree with this view, but I'm not sure there's a practical way, or B, that it's even desirable to end that. I mean, again, we can all think of firms on both sides of the aisle, or, whether they're private firms or public interest firms, that clearly do want to go out and brand themselves as, representing one side of an issue or one side of the aisle. And, they are probably going to be candid about that in discussions with the law firms they work with or with the clients they take on. And, I don't necessarily think we want to try to stamp that out.
Okay, thank you. So now looking at the questions that have been posed by the audience, and please, again, feel free to add your own to the Q&A. I'm going to sort of group them and pose them to different folks. So we have had a couple of questions about the lawyers who represented former President Trump in contesting the results of the 2020 presidential election. One reader pointed out, or listener pointed out, that disciplinary proceedings against John Eastman just began today. There have been disciplinary proceedings against other lawyers for the former president, including Sidney Powell and Rudolph Giuliani. So actually, let me pose this question to David Boies, since you litigated a kind of prominent election case by the name of Bush v. Gore. What do you think about these efforts to bring disciplinary proceedings against Trump lawyers, and could they have a chilling effect on lawyers representing politically controversial clients or causes?
I think there's always a danger when lawyers get disciplined for representing politically unpopular causes. However, I think the standards here that are being applied are normal, traditional standards of behavior. That is, I don't have any sense that the disciplinary proceedings that are being brought are creating a new law. It's the kind of obligations that you would have whether you were representing a commercial client or a politically prominent client. So I think there is a danger there, but I don't see that danger in these particular cases.
Does any other panelist want to comment on that? Go ahead, Carissa.
Yeah, I'll just add, my understanding from having read some of these complaints is that they are some pretty, as David suggested, sort of ordinary misconduct that people like to flag and bring to the attention of the bar authorities. I'll just say, I think anytime you're going to have disciplinary enforcement, we have to keep in mind how infrequently these rules actually result in discipline. And that sort of infrequent enforcement is sometimes what people are concerned about, right? They're not so much concerned about the particular claim here. They're wondering whether, if this hadn't been a high profile political case, if the bar authorities might have looked the other way. We don't have a lot of insight into the enforcement because so many of the, so much of the complaint process is opaque and purposely so for confidentiality reasons. But because it's such a black box, and because we know, because they talk about it sometimes in the preface, that there's sort of deliberate under enforcement of the rules, I think that discretion is always going to leave people wondering.
Yeah, and I think there's a sense, for people who are concerned about these disciplinary proceedings, I think there's a sense that they started with a clear political agenda, and then if anything, they backed into a reasonable bar complaint, right? So I don't disagree with David that at the end of the day, you can point to, and a lot of these are still playing out, so it remains to be seen. I hope it's true that at the end of the day, we will say that every bar committee took a reasoned and measured approach to how they handled these cases. But I don't think it's unfair for someone to say, kind of as Professor Hessig indicated, this doesn't look like a mine run case of attorney discipline. Not sure it would have been brought if it weren't for the political valence of the case. And at least some of the initiation of these, right, when a 300-page bar complaint is filed by a clear ideological opponent that had nothing to do with the representation, right? This is not a client victim coming in and saying, I was given poor representation. This is political opponents filing bar complaints saying somebody should be disbarred because I don't like them. Again, without kind of getting into the ultimate merits of those cases, I think there are plenty of unique circumstances that it makes sense why people are concerned about it.
Yeah, I agree with everything that's been said, and just said another comment. There were, during the Trump administration, I think there were some complaints, if I remember correctly, one brought under 8.4C for dishonest conduct or making statements engaging in conduct involving fraud, deceit, dishonesty, or misrepresentation, involving truly a political statement by, I think it was Kellyanne Conway, and someone made a bar complaint about that. I mean, that's an example. That's political speech. Disagreement about what's true and not true in the context of those kinds of contexts, I think, is where you can see a significant amount of abuse. But in other cases, even if the motivation's poor, it depends, as we always tell law students, it depends on the facts. It depends on what was done specifically here, what the intentions were. So, but it is, you're right. I think with the discretion, as Professor Hessig mentioned, with the discretion, it does gives rise to some questions about, well, why this one and not that one? And having been a former bar counsel, you have to be in a position to defend decisions. I didn't have one like that, but you have to be able to defend what you decide to do and why.
Well, let me stay with you, Professor McGinnis, and pose a question from one attendee. This person observes what David Boyce pointed out, that we are engaged in this great ideological sorting or realignment, and this trend is very hard to resist. This person wonders, is there even a point in resisting this trend? And writes this questioner, why not let Paul Clement go off and do on his own what he likes, litigate Second Amendment cases, and let Kirkland do what it wants to do, generate revenue from non-controversial matters? And this person asks, how would we, as lawyers and as a nation, have benefited if Kirkland had kept Paul Clement around, just diluting both of their brands? So why don't I start with you, Professor McGinnis, but then anyone else who wants to chime in on that could.
Thanks, David. That's an excellent question and a challenging one, of course. I guess this steps back a little bit to my philosophy of this in general. I think Professor Hessek was talking about these traditions 1.2b, where you're not identified with the views of your client. We give a lot of discretion to individuals to who they're going to represent, right? But they also have an out clause, which is 1.16. If they find what the client is doing repugnant, they have the ability to withdraw from representation. So philosophically, I take a very strong view in terms of individual rights of client selection, like not to be compelled to represent someone against conscience. Even if 1.2b exists, that I don't have to necessarily use that as like, well, then no one can, I can't question my own conscience because the rule says I shouldn't. Where I find to be a concern, this is where I think having norms, even if they're not necessarily always black letter rules, and maybe it ends up being commentary to the rules, but norms in the profession where others can't bring to bear, whether it's in, and I know we're primarily talking about client coercion, but I also worry about large law firms simply saying, you will not be able to be associated with our firm anymore if you're going to represent X cause, except under, maybe a boutique or particular cause law firm. I think that's a concern in terms of the signal it sends about the ability to access the best representation, to be able to cut off a whole stream of lawyers from those opportunities. There's resources that large law firms can bring that even Paul Clement on his own, maybe obviously tremendously talented, skilled, amazing advocate, but he can handle that. But necessarily, what about the lawyer who wants to do similar things but doesn't have that sort of that capital to necessarily pull it off? So I worry about what happens downstream in terms of the legal culture, and how if there's not a norm, as John said, with having these rules in some way to reflect, or the comment to the rules to reflect that. I'm concerned about that. And one quick comment on John's rule. I think it's excellent. One thing I thought of, it goes a little bit to your question, David, about it says agreement. It doesn't reach the sort of, well, I'm not reaching agreement. I'm just telling you what I think, and so I'm going to proceed. That's an area where you can sometimes, or maybe it'd be worth considering adding some comment language ahead of the sort of clarifying point about conflict of interest. Says, here's why this rule is being put into place. We see that elsewhere in the model rules all the time, but it sets the stage. It says this has a communicative benefit that tells the lawyer, and then you can show it to the client. This is the reason why this rule exists. This is why this is a concern, and hopefully it provides some additional support from the profession for making that resistance or resisting that pressure, and say it's just part of the institutional norms that's reflected both by this black letter rule that is the one that subjects lawyers to discipline, reaching agreements, and then this principle that's stated in the comment, which articulates why we're putting this provision into place.
Let me see. Go ahead.
Yeah, I would add just a brief comment on what the problem is. Why do we care? I don't think we particularly care about what happens to Paul Clement and Kirkland Ellis, because they're both going to be fine. I think what we care about is the principle, because that principle is going to affect a lot of people other than Paul Clement and Kirkland Ellis. It's going to affect a lot of people who may have difficulty getting representation. We've seen historically a lot of people who needed representation and could not get representation. When I started practicing law more years ago than I like to remember, in the middle 1960s, doing civil rights work in Mississippi, one of the reasons I was down there is that no white lawyer would represent blacks in conflict with whites down there. They couldn't get representation. And the reason they couldn't get representation was because clients and other lawyers would ostracize them if they took on those kind of representations. And I think that the profession as a whole, not just the profession that was interested in the civil rights movement, but the profession as a whole pushed back against that. You had the Lawyers Committee for Civil Rights formed in the White House to try to deal with the principle that people ought to be free to represent clients, even unpopular clients, and even clients advocating positions that the community found offensive. So I think there are two principles at work here, and they're different. One is that the lawyer ought to be free to take on or not take on a case, subject only to the qualification that as a profession, we have an obligation to make sure that everyone has an opportunity to be represented. But assuming that there is representation out there, I think lawyers are free to become pro-abortion or anti-abortion lawyers, pro-progressive or anti-progressive lawyers, if that's what they want to do. However, I think there's another proposition, which is that lawyers ought not to be intimidated, ought not to be penalized, ought not to have boycotts or pressure brought to bear upon them because of the choices that they make. That if John Adams wanted to represent the British soldiers, he ought to be prepared to do that. If they couldn't find other representation, I think he had an obligation to do that. But assuming that they had other opportunities for representation, it was up to him. But it was not the kind of thing that ought to be prohibited, because when you start imposing those kind of limits, it is the weak and the vulnerable in our society that are most going to suffer. And it's not the Paul Clements, it's not his clients, it's not Kirkland Ellis, it's not their clients. But this principle is important to the functioning of our justice system.
Anyone else?
Yeah, if I can just piggyback on that, and I'm so glad that you framed it that way, David, because I understand that this is a panel on client coercion, but the rule that we're talking about is a rule that is aimed at lawyers on both sides, because that's what professional responsibility rules are, right? They're aimed at lawyers. I don't think that that rule is going to get at the problem that David put so eloquently, right? Which is about access to justice for poor and powerless people, because those poor and powerless people aren't going to have, their own internal lawyers advocating on their behalf, right? I think the sort of people that David's talking about, right? The people who are out of power, the people who don't have resources, the people who don't have leverage in society. I think we all sort of intuitively know who those people are, and maybe they've shifted over time, but those are the people where the scruples, right? Whether they're business related scruples or internal conscience related scruples are going to lead the lawyer in his or her professional judgment not to take on those cases. So to the extent that this is about norms, about equal access, I don't think that telling clients that they shouldn't use their financial clout to stop lawyers from taking other clients addresses that issue. I think it only addresses the issue for one side of a political debate or one side of some other situation where somebody has a lot of resources. I think we're all, or many of us, are sort of poo-pooing that idea and saying independent judgment of the lawyers, it's totally fine, they should be free to make up their minds on these sorts of things. I think we just need to acknowledge that that means an awful lot of people are probably still going to go unrepresented, or they're only going to get court-appointed representation, or if they're not in a situation where they're entitled to counsel, they'll have to proceed pro se. Now, maybe everyone's okay with that, because what we're really trying to stop is client coercion that's about certain types of political fights. But I'm not so sure that that's where I come down on things. I'm more interested in what David's talking about, which is making sure that everybody can get access to high quality counsel. And I think that that actually requires lawyers to stop placing so much emphasis on their own individual feelings about who they ought to represent or not, and maybe feel more of an obligation to represent people that we might find distasteful or with whom we disagree. And if that were more of the norm, that might deal with some of these sorts of problems.
I think that's a good point. I think to respond to it, though, there's, I think by removing one piece of pressure, you do open up room for lawyers to cultivate that secondary norm that you referred to, right? So, there are not, I've seen law firms have done a lot of pro bono efforts on, big causes over the years. Famously, lots of big law firms jumped in to represent Guantanamo Bay detainees who are not a particularly politically popular group. I mean, really politically popular only in the sense that people value lawyers doing what lawyers are thought to be good at doing, which is representing unpopular clients, right? I think that's the entire popularity of those cases. We have not seen that for January 6th defendants in a way that a lot of young litigation associates could get some really great hands-on trial experience representing January 6th defendants. DOJ is bringing a ton of these cases. You get a chance to take things to trial quickly. You do it against, the best lawyers in the country out of the U.S. Attorney's Office in D.C. Haven't seen a lot of that going on. And some of it could be kind of the personal choices of individual lawyers who say, that's not a case I'd be interested to take on. But I suspect that nobody really feels like they have the meaningful opportunity to make that choice in the first place because, whether it's from the firm or from other clients, the perception that I'm just going to be crushed with no's if I even bring it up.
I think that it's actually very, very true that an awful lot of lawyers don't take on clients that they should because they don't approve of them or don't think they deserve representation. But I think a lot of that comes from the sentiment that is out there in society generally and in the legal profession that identifies the lawyer with the client. A friend of mine, Bill Duker, was once quoted as saying, if a lawyer represents an axe murderer, it doesn't make him an axe murderer, it makes him a lawyer. And I think that we need to understand that when lawyers begin to identify too much with their client in their closets, when that happens as a matter of our profession, not just a matter of a small part of the profession that chooses to do advocacy work, but when our profession as a whole begins to identify with clients, and when clients expect lawyers to identify with them, we begin to lose the ability to perform the function that we're supposed to be performing in our justice system. This is an adversarial system. We are representing a client. We're not making the decision. The judge and the jury makes that decision. It's our obligation to present the case the best way we can. And I think that when we lose sight of that, I mean, it caused all sorts of things. It makes lawyers treat other lawyers poorly. People were always surprised, I thought a very unfortunate kind of surprise, that Ted Olson and I or Chuck Cooper and I get along so well, despite the fact that there are very few things in terms of law and policy that we actually agree on. But I think that the need to recognize that we perform an important function in our justice system, and that is an adversarial system. That's an adversarial function, and we are presenting the facts. We're presenting the law to the decision maker. We're not the decision maker, and if we try to become too much of that, I think we undermine the real role that we can contribute.
David, I appreciate all these comments. I have just a couple quick things to add. I think there's a distinction, and I appreciate Professor Hessig's comments too about the importance of providing representation and not over-identifying or saying, I'm not going to represent you because I consider you distasteful or what you represent distasteful. But I make a distinction in my own mind between, for example, the criminal justice system, where the issues are about what you are alleged to have done and whether you're a popular or unpopular person, versus sort of cause lawyering, where a client wants a lawyer to take on a particular case that advances a particular objective that from a moral standpoint, they individually find objectionable. So it's kind of like the Thomas More Man for All Seasons idea, which is, I'm going to take my stand. I'm going to assert my conscience, as he did with King Henry VIII. But when he was asked by his friend Duke of Norfolk, You just said, well, why are you being so stubborn? Well, he said, well, you do what your conscience tells you to do. Other lawyer in my firm do what your conscience tells you to do about taking on a particular cause, and I'll do mine. I'm paraphrasing. Robert Bolt put it much better in the play. But the idea is that I think that's where the concerns me, the idea that if any lawyer in our, I'm going to use my economic power as a client to try to coerce all the lawyers at a particular firm to not represent a cause that I find distasteful, even if they, as a matter of conscience, would like to represent that cause, or other lawyers in the firm, for example, partners, pressure an associate, don't take this pro bono case for a pro-life organization because we find that objectionable. I think in a pluralistic society, and large law firms are fairly pluralistic, filled with a wide diversity of people, I think that's where I get concerned about that sort of pressure, or what David Boyce referred to earlier, is that sort of bringing pressure to bear upon your decisions about who you're going to represent and who you want to provide your legal services to. So it's a freedom issue at the individual level. Understanding there's also law firms, as we've talked about, that would identify with a particular cause. So they're going to say, well, if you join our firm, these are the kinds of things we do. And I think that's certainly legitimate as well.
So one question posed by a listener, and I think it relates to some of the things we've already discussed, but this person asks, from personal experience, a practice can be built by referrals from those reluctant to take unpopular positions. Isn't that the answer to providing adequate representation of the poor and downtrodden? So let me send that question to David. What is the problem with having certain firms or lawyers build very profitable practices, taking on the unpopular causes of the world?
A lot of times the unpopular causes are not that profitable. A lot of times the people who most desperately need legal services don't have the resources to pay for it. I think that the obligation to provide counsel and the obligation of an adversarial justice system of having competent adversaries to represent people is not solved by simply saying, well, let's pressure, let's all the people with money, let's pressure lawyers not to take on these cases and hope that the people who need the representation will be able to find the money to pay for it. It doesn't happen that way in the real world.
Yeah, no, I think that makes sense. And alluding to something that Professor McGinnis mentioned earlier, and something that Paul Clement mentioned when I interviewed him for my original jurisdiction podcast, boutiques aren't a perfect substitute for large law firms. There are certain matters that are, say, a complex pro bono trial, for example. There's certain matters that large law firms can do very well that a boutique can't, because it just doesn't have the bandwidth. So I do think there's something to that. Let me pose a question to Jean Moran. This person asks, isn't the underlying concern this? Since almost all big law firms lean left, there won't be enough space in the upper echelon of the market to absorb young conservative lawyers if large firms start culling ideological outliers. And if I can just kind of frame this question at a broader level of generality, I guess the question I would say is, what about talent recruitment? And do you think these issues affect law students and young lawyers who are choosing firms? One thing that was said about Kirkland was, well, they turned these gun cases away because there are a lot of young associates and law students that they need to staff their private equity deals who don't want to go to a firm involved in these types of cases. So I guess that's the question. What ideology, hiring, your thoughts on that?
Sure. I think that is an important issue, and it's one that probably in some respects does overlap with the issues that we've been discussing today. But I think it's also kind of its own bucket of issues, which I'm happy to talk a little bit about, briefly. I think that the commonality is that both reflect this idea that's very common in progressive politics these days, and Professor Hessek kind of touched on it, that we should take the levers of power and we should employ them, in favor of our preferred policy outcomes. And we should do that, frankly, whether or not, or even especially if that means kind of tearing down traditional norms and institutions that would stand in the way of doing that. And I think, there are efforts by, one would be a client who says, hey, I have a lot of institutional power that comes from my law firm relationships, and I should leverage those to influence the types of legal representation that are available to the people I dislike in the political space. Another I think iteration of that is law students who are exploring the idea of using their kind of bargaining power as law firm candidates to do that. I mean, obviously they're in a little bit of a different seat from law firm institutional clients in terms of how much leverage they have over law firms, although at least in some cases they seem to be achieving some success. I mean, I think the question I would put to the group is just, is that what we want from the is that a good thing from the youngest lawyers among us to say, we're coming in, we're using our whatever leverage we may or may not have, we're doing it to kind of reshape these firms from the ground up in terms of what types of cases they're willing to take on and what types of cases they're not. My personal view is that regardless of your political background, I'd like to find associates who embrace the best traditions of the legal profession and want to cultivate those and develop them in service of our shared clients. But maybe that just makes me old-fashioned.
So we are coming up on 2:30. So let me just ask each of the panelists if they have any final thoughts they want to share. And why don't we just go in the order in which you made your original presentations? David Boyes.
I would just say to Professor Hessig to ask your students to reflect on what the consequences are of focusing on means rather than, and ends. Once you begin to say that the end justifies the means, you hand a powerful tool to people who have ultimately more power than you do.
Professor Hessig?
I will say that, but also, if you'd like to come speak to my students in professional responsibility, I think that they might be more interested in hearing that from you. So I'll be in touch.
Okay, good, good.
That would be pretty amazing to have David Boyes come in person or by Zoom. Professor McGinnis?
Yes, just very briefly, I echo David's comment about ends justifying the means. Of goal-based ethics, I think, are precarious, and have a way of working out in ways that students might not expect, along with lawyers. But also just to reiterate the importance of we're in a pluralistic profession. We're in a diverse society. I guess part of what my global concern goes along with that last question that was directed by you, David, not to John. Have space for competing views, competing ideas, competing ideologies, especially within our larger institutions. I think where the risk is, going back to the idea of independence, that if the profession itself can't establish norms, whether it's through black letter discipline or just cultivating stronger understandings of what's expected about, not try to step on the toes of others who are trying to do their legal work, but focus on your decisions and what you're going to do, or what as a client, what your own interests are, as opposed to trying to impose ideological binders on your law firms. I think we're going to run the risk not only of violating those historical norms, but politically, the anti-independence movement could go in, and there could be more regulation from outside to decide what these things are going to be. I can anticipate a future Congress, for example, depending on the administration, taking a very hard look at things like this if the profession itself can't straighten it out suitably. So that's always in the backdrop of any number of professional responsibility issues. Is Congress going to do something about this at some point? And we've avoided most of that, but I think it's an important consideration for those who are looking at it from a practical standpoint, in addition to the principles that David Boyes so eloquently articulated too. So thank you.
And finally, John, any last words to add?
Yeah, well, thanks again to Alita and the Federalist Society for putting this together. I mean, I'm an eternal optimist, so I feel like these things will eventually trend in the right direction. I think in the broader corporate landscape, we're already seeing some kind of reconsideration of ESG, at least phase one of ESG, that comes not just from people who were opposed to it from the beginning, but the people who kind of realize that it's turned in on itself and has started eating them. And I think you may, see some of that in the legal profession too, as people who initially think, hey, clients can do, they're the boss, the increased kind of professionalization, or I guess I should say, kind of businessification of the law that David talked about, that, that might seem fine when you're on the receiving end of a great partner distribution at the end of the year. But then when it turns around and starts cannibalizing your client base, there are going to be people, I think, across the political spectrum that start to pine for the traditional norms of the practice. At least that's my naive, optimistic view. So thanks again.
All right. Well, thank you all for joining us. On behalf of the Federalist Society, I want to thank our panelists and moderator for the benefit of their time and expertise today, and thank our audience for joining and participating in the event and offering really thoughtful questions. We welcome listener feedback by email at info@fedsoc.org. Our next event is scheduled for June 28th, a one-day Freedom of Thought conference. It will be in person at the Mayflower Hotel and live streamed. You can find more information and register on the upcoming events page at the FedSoc website. Thanks again for joining us. We are adjourned.
Thank you for listening to Open Minds, a Freedom of Thought podcast series interviewing the people who bring courage and independent thought to the challenges of today. To learn more, visit freedomofthought.fedsoc.org.